Nancy Cavey, National ERISA and Individual Disability Attorney, and I want to welcome you to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast is not legal advice. The Florida Bar Association says I have to say this, so now I've said it. But nothing will ever prevent me from giving you an easy-to-understand overview of the disability insurance world, the games the disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. Are you the owner of a small business? This week, we're going to be touching on what every business owner and professional practitioner must know about ERISA disability insurance. If you don't own a business, there's still some things I think you need to learn. I'm going to be talking about three things today. First, is your policy governed by ERISA or is it an individual disability policy? Should a small business owner being paid disability insurance benefits take a draw or a distribution? And lastly, don't mess with a disability carrier and fail to tell them about work activity, a tale of how one attorney destroyed his disability case. Let's take a break for a moment before we get started. Welcome back to Winning Isn't Easy. I'm going to tell you a story. I think stories are instructive for lots of reasons. Not only are they entertaining, but more importantly, you get a sense of what disability carriers do and what judges do with disability insurance claims. So this is called Don't Mess with a Disability Carrier and Fail to Tell Them About Work Activity. It's a tale of how one of my colleagues, an attorney, destroyed his disability case. So when the disability insurance carrier puts you on claim or what's called diary, you're going to be asked to fill out forms. And one of those forms is going to be an activity of daily living form. It's going to ask you questions about your activities, including work activities. You have an obligation to tell the truth. And if you don't, your claim can be denied. And worse yet, if they catch you in a lie about your work activity, the disability carrier just might sue you to recover disability payments they made to you. So let me tell you the story of Mr. Messing, who lived up to his name, and he messed up his disability claim big time. We've touched on his story in past episodes, but I want to reiterate this story and I want to expand a bit on it because I think it's important for you to hear. Now, this is about misrepresentations about work activity. Mr. Messing was a former partner in a law firm, and he knew the likely consequences of making a misrepresentation on his activity of daily living forms. Misrepresentation, in my view, is a fancy legal term for lying. Messing claimed in 1998 that he was disabled because of depression, and he was unable to handle the stress of being a trial lawyer. Unum Provident accepted the claim, and they paid him benefits until 2018. And guess what? They found he was able to work as a lawyer and they terminated his benefits. Messing had never disclosed that between 1999 and 2013, he had worked on 13 legal cases for which he had been paid. The failure to disclose that work and the money he earned on his activity of daily living forms would come back to bite him, and you know where it bit him. It was in his wallet, right? Unum Provident did a simple search using something called Pacer, and they typed in his name, and out came information about 13 cases. And while this information was ultimately not part of the administrative record, it didn't help his case. So what did Unum do? Well, Unum counterclaimed for restitution of the disability benefits. So when he sued them, they counterclaimed, and they said, look, Messing misrepresented his inability to work as an attorney, and we want our money back. Now, fortunately for Messing, the judge found that Unum Provident had met its burden to show that the misrepresentation had induced the payment of his disability benefits. The judge concluded that at best, Unum Provident only showed it would have investigated the claim had it known about the misrepresentations, and that it was speculative as to whether or not that information would have led to a claim denial back in the past. But ultimately, Unum prevailed. And by that, I mean, while Messing didn't have to pay the money back that he had been paid from 1999 to 2013, the judge ruled against him in his disability case. and found that he was able to work as a trial attorney and was no longer entitled to benefits after 2018. So, what's the lesson here? Well, the lesson is you shouldn't give the disability carrier reasons to deny your claim. And they're not in the business of paying benefits, and they're always looking for a reason to deny benefits. When you make a misrepresentation, however, that can result not only in a claims denial, a claims determination, a claim for restitution, but worse yet, it can even result in a referral to the Department of Insurance for a fraud investigation. And even worse for Messing, his misrepresentations could result in a bar complaint and an ethics violation investigation with a possible loss of his legal license. Like your mama told you, tell the truth, and tell the truth. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, consider liking our page, leaving a review, or sharing it with your friends and family. Also, why don't you subscribe to this podcast? That way you're going to be notified every time a new episode comes out. And I want to remind you, our 2022 Cavey Law Scholarship is up and running. And we're taking entries until August. Head over to caveylaw.com/scholarships to enter. A family member or a friend whose child is going to college and could benefit from a college scholarship. I hope you tune in next week for another insightful episode of Winning Isn't Easy.